This is Bloomberg Law with June Grasso from Bloomberg Radio.
You'd think Elon Musk would be on his best behavior at Tesla ahead of a shareholders vote next week on his $56 billion pay package, considered to be the largest for a CEO in corporate America. Yet on Tuesday, we found Musk confirming that he had ordered artificial intelligence chips meant for Tesla to be sent to his social media company X, offering explanations both for the redirected shipment and for internal NVIDIA emails that cast doubt on the car maker's procurement plans. And then there's a new investor lawsuit accusing him of $7.5 billion of insider trading in Tesla stock. As usual, things are litigious in Musk world. Joining me to sort it all out is business law professor Eric Talley of Columbia Law School. Musk told NVIDIA to prioritize shipments of AI processors to his company X over Tesla. CNBC first reported that on Tuesday, and Musk went on X to confirm it, saying Tesla had no place to send the NVIDIA chips to turn them on, so they would have just sat in a warehouse. Is this a problem for him?
Listen, this is a problem anytime you've got an executive that is essentially sitting in control of two companies that are either in competition with one another or potentially in competition about inputs with one another. And it has long been known that in the EV sector, the access to computer chips has been one of the big juggernaut constraints that industry has faced. And so the news CNBC has broken about the sort of demotion of Tesla in the receipt of these NVIDIA chips is a potentially large concern. Now, whether it's the case or not that Tesla didn't have a place to put these chips, that's a different matter. I definitely remember that Elon Musk himself had made a point about saying that Tesla was ramping up its procurement of these chips as a mechanism to try to ensure that this one huge supply constraint wasn't going to affect Tesla. The broader point, however, is that if you've got someone who is, essentially trying to steward the ship at a bunch of different companies that are each interested in the same input or the same resource, it's almost inevitable that you're going to have to make triaging choices yourself about who gets first dibs on this particular asset or resource. And that always poses a challenge when it comes to, what are your fiduciary duties? Go back, June, the kind of the foundational way that people lay out, or judges and courts have laid out fiduciary duties over the years, is that it's a duty of undivided loyalty. But when you are dividing your time between multiple companies and each company you owe a duty of undivided loyalty to, that becomes a problem, right? Something has to give in that context. Now, it may well be the case that Tesla had no use for these computer chips. That's an assertion that Mr. Musk has made, and that would, if true, dampen the extent to which the two interests were in conflict with one another. But that is a statement that's not necessarily consistent with other statements that he himself has made about this, and certainly not consistent with the way that the EV industry has been essentially stalled, at least in part because of the availability of these resources.
Tesla shareholders are voting on June 13th on a pay package for Musk that's considered to be the largest for a CEO in corporate America. Whether this will play into their votes.
It's a big factor. I guess I should first say that, there's a lively and interesting debate about what the effect of this stockholder vote would actually be. Would it have the power to overturn the judgment the lower Chancery Court issued earlier as to his pay package? Would it complicate it in any ways? And there are some people that think it would have no effect, some people that think it would be absolutely enough to approve the package. I tend to come down in the middle. I think the odds are stacked a little bit against it. There might be a few windows by which it could be useful in a multi-pronged attempt to try to appeal the judgment. So even the outcome of the stockholder vote, if positive for Mr. Musk, doesn't necessarily put itself on a glide path to actually approving the deal that was disallowed back in the beginning of 2024. But that is even assuming that the vote goes forward and the vote is favorable towards the pay package. One of the things that this most recent controversy sort of, resurfaces is a concern that, hey, if you're a Tesla stockholder and you are now becoming increasingly worried that Mr. Musk is sometimes giving goodies to Tesla, but sometimes giving them to X/Twitter, sometimes giving them to SpaceX, sometimes giving them to Neuralink. And in fact, you cannot buy stock in those companies because they're not publicly traded. That creates a concerning amount of leakage from your own investment. If you're a big institutional investor that has been allowed into the walled garden of investing in SpaceX or investing in Neuralink or investing in Twitter, then, how Elon allocates these goodies between the companies, it may not matter as much because, you'll be on the winning side and the losing side at the same time. But if you're a Tesla public stockholder that doesn't have stock in these other companies, and most retail investors cannot have stock in these other companies, it's a big concern. You want to make sure that your milk money isn't being stolen to subsidize or support, the next moonshot or the next SpaceX mission, because that's not what you signed up for, right? That's nothing that you're going to make profits from. So lawyers sometimes refer to these things as corporate opportunities, a supply contract, the initiative in AI and robotics. Is this a corporate opportunity that rightfully belongs to Tesla and shouldn't be spirited out of the company, or is it something that's just not within Tesla's line of business?
The shareholders are voting under this threat by Musk that unless he has 25% voting control, he'd prefer to build products outside of Tesla.
And in fact, he has begun to raise money for an AI initiative that he's called XAI without committing on whether that is going to be directed into Tesla or somewhere else. So this, in some ways, is the instantiation of exactly this type of concern, that you don't really know if you're one of these public investors in Tesla whether the capital for your investment is actually going towards the resources that you're expecting it to go towards, or the most profitable resource is going to be siphoned off or redirected to one of these other companies that you didn't invest in. And this is kind of related to this idea of having undivided loyalty. The field of fiduciary duty law has a specialty inside it called the corporate opportunities doctrine. And this is one of the thorniest areas to navigate. It often ends up creating big trouble for people who are trying to straddle influence on multiple companies, because if some new business opportunity comes up or an existing business opportunity meets the care and feeding, do you direct it into one company? Do you direct it to the other? Do you just take it for yourself and so forth? And this can be an intractable problem for a lot of people to try to navigate. It's actually been such an intractable problem over the years that about 25 years ago, the state of Delaware changed its law to allow companies a little bit more freedom to say, oh, you know what? We don't need to worry about corporate opportunities in a particular category, whether it's, GPU chips or whether it's something else. And you can do that, and you can sort of promulgate one of these waivers. It's an allowable thing within Delaware law. And in fact, SpaceX has one of these waivers. Sort of says, look, if Elon Musk wants to pull something out of SpaceX, we're going to disclaim certain types of categories of corporate opportunities. But Tesla has never had one. And so there's a sense in which that issue of Tesla's corporate opportunities is pretty much still the traditional rule, which is that, if it's within the company's line of business, it's something that the stockholders might say rightfully belongs to them. And that creates another problem with this vote, which is that, even if you think that the vote itself will have legal effect, that'll make it easier for the compensation package to now be approved and actually awarded or re-awarded to Mr. Musk. The predicate assumption there is that this shareholder vote is taking place on both a fully informed basis and also what is known as a non-coerced basis. In other words, you can't have a metaphorical gun to your head, or the sword of Damocles is hanging over you as you're thinking about how you're going to vote. And some of these not-so-veiled threats of, hey, if I don't get my way, if I don't get my 25% of the company, I'm going to take this project and I'm not going to let Tesla pursue it. I'm going to pursue it elsewhere. That has an element of coercion in it that, weirdly enough, can invalidate a stockholder vote or the effect of the stockholder vote. So even though Tesla has now, basically put out this proxy set of materials with copious amounts of information disclosure, including the entire opinion that Chancellor McCormick wrote in this case, they've definitely solved the you haven't informed your stockholders problem, and they've done so quite admirably. But at the same time, Mr. Musk and some other folks are starting to hint that, hey, if the vote doesn't come out in Mr. Musk's favor, he may visit a world of hurt on the company and therefore on stockholders. And that can actually have a backfiring effect by essentially robbing the stockholder vote of legal effect, not because it wasn't informed, but because it was coerced. Those are the two things you're not supposed to do when you're getting a stockholder vote, is to rob people of information or withhold information or make them feel like they're voting in a coerced way. Tesla's fixed one. I have some concerns that they're starting to imperil themselves on the second.
And there's more. There's so much more. There's also a suit accusing him of insider trading when he sold more than $7.5 billion in Tesla stock in 2022. This is about the time, I guess, when he was looking for money for the purchase of Twitter.
Absolutely. This is exactly the moment where he had to find some liquidity in his stock. Here I have some sympathy for Mr. Musk, because the fact of the matter is, he was going to have to close this deal and he was going to have to come up with cash. And the only place that he could come up with cash, really that amount of money, was through, getting some liquidity in his Tesla shares. So he had to sell them. And this kind of causes us to back into a very awkward aspect about federal law, right? It basically says you're not supposed to be buying or selling stock while in possession of material information that the public doesn't have. CEOs, their entire day consists of possessing material information, right? And so if you take that too literally, it's almost like, well, a CEO can't ever buy or sell stock because they are always in possession of material non-public information. Now, there's a fix that ordinarily works for this, is that there's these special automated programs that just use an algorithm to buy and sell stock on behalf of the CEO. So the CEO isn't actually pulling the trigger on those sales. That's what's sometimes known as a 10b5-1 program. That's what the term of art is. But that wasn't going to be appropriate here, because this was not just sort of the regular sort of portfolio management buying and selling stock. He needed to liquidate a big chunk of this so that he could make good on the purchase price for Twitter, and this was the only way to do it. And so in some ways that may actually be his saving grace in this case, is that it's pretty clear he needed to come up with this money. Second, it's pretty clear that he's always a CEO going to be in possession of material non-public information, both good or bad. But the thing that was motivating to do this was not to make money off of the material information, was really just to get the liquidity of his stock taken care of.
Coming up next, the judge in the insider trading case knows Musk well. I'm June Grasso, and you're listening to Bloomberg. I've been talking to business law professor Eric Talley of Columbia Law School about a Tesla shareholders' lawsuit against Elon Musk alleging insider trading. The suit claims that Musk had inside knowledge of a miss on production and delivery numbers that Tesla was facing when he sold more than $7.5 billion in stock in 2022. It's just the latest dispute over Musk, his stock purchases, sales, and talk. Eric, this case is coming before Chancellor Kathleen McCormick, who's dealt with Musk before. She oversaw the case over his unsuccessful effort to back out of buying Twitter. And in January, she voided his $56 billion pay package after finding that Tesla directors who approved it in 2018 had a conflict of interest and that Tesla failed to properly disclose the terms of the executive compensation plan. Is it just luck that he keeps getting McCormick?
Well, so it turns out that, anything that is justiciable in front of state courts, and, some federal claims are not, but they sometimes get lumped in with state claims, and they're going to be then heard in front of the Delaware court if they're heard in state court. The Delaware Court of Chancery has generally not operated under, sort of a, ping pong ball randomization approach when cases come down. They basically say, okay, look, there are certain judges that have developed an expertise in a particular sector and a particular set of disputes. And Chancellor McCormick, also because she's Chancellor of the court, so of the judges on the Court of Chancery, she is sort of the top of that hierarchy. It is generally seen as the Chancellor's responsibility to take on the thorniest cases. And so it's just not surprising that a case that ends up landing in Delaware is going to draw Chancellor McCormick to it once again, simply because there's an awful lot of backstory here. Now, it's worth noting that Chancellor McCormick hasn't always been presiding over Tesla litigation. When the compensation case actually started, it was a different judge who's now left the court, Vice Chancellor Slice, who also presided over the Solar City Tesla litigation. So, she sort of moved into being kind of the expert in all things Tesla when Vice Chancellor Slice left the bench. But it's just not surprising that things that circulate around similar topics are going to draw similar judges. And I can think of no more of a similar topic than things that involve Elon Musk, which seem to be attracting attention left and right.
Eric, isn't it usually the SEC who finds out about these insider trading schemes or charges first before investors?
It typically is. And so there are sometimes some lines of demarcation that basically say, look, this can only be brought in federal court, or it could be, even though it's a federal claim, it can be brought in state court. And there are certain types that absolutely cannot be brought in state court, that you've got to bring them as federal court. And there are some that kind of bleed over. They involve both some state fiduciary claims and securities claims. And there you can end up having a state court end up hearing it. It wouldn't surprise me if in this case there was some sort of a motion to say, look, this is not one of those cases. This is an entirely federal case, and this should be moved to federal court. That's certainly a possibility. The case really just, first shots have just been fired.
Do you think it's a good case for the shareholders, a strong case?
Like I said, the argument that, hey, you're not supposed to be trading while in possession of material non-public information. He's the CEO. He had this non-public information about the future of performance reports of Tesla, and he nonetheless sold a big chunk of shares. That's got all of the ingredients of a valid cause of action. I think the biggest argument against it was the fact that it seems implausible that the thing that was motivating Mr. Musk to engage in this sale was his desire to get out while the getting was good, as opposed to, I need liquidity for my stock so that I can, essentially make good on this rather improvident offer that I made on Twitter. And looks like I'm going to have to close that deal. So I think that probably is the most likely motivating factor, as opposed to anything that has to do with securities fraud. There is a state of mind requirement when you're engaged in securities fraud, and that may actually play a role here, right? Did he have a culpable state of mind in doing this, or was this really for a totally different reason? And of course, he couldn't help being in possession of material information because he is the CEO. Heck, he's the CEO of like 6 different companies.
It's hard to keep track of all his legal issues. He's also sitting down for a third round of questioning with the SEC, who's investigating his Twitter purchase. I'm surprised that's not over yet.
Yeah, I think on some level it probably would have been over, but as you might recall, June, he no-showed at least one of those earlier appointments. So I think this is going to be basically another requirement that he come in and this process see its way through. The underlying allegations there are not earth-shattering, but they are, at least as alleged, they are a technical violation of what you're supposed to be doing when you are thinking about taking over a company, which is that you're supposed to reveal yourself publicly once you've crossed the 5% ownership threshold, and you have a limited amount of time to do that. And the allegations is that he delayed too long. And that's an important set of rules of the road for the SEC to keep established in a publicly observable way. In fact, they just shortened those timelines since the Twitter acquisition. So I think in some ways this is, an attempt by the SEC to sort of say, no, we really mean it. These rules are there. They're there for a reason. And we are not going to look past violations. And so I think that it may be as much of a symbolic victory that the SEC is going after as opposed to anything else.
Have we covered all his current legal issues?
Well, maybe and maybe not. I will say that it is uncommon to see someone who ends up as the chief executive officer of so many companies that are in similar spaces with one another. And part of the reason probably has to do with, 2 things. Like, one is just a constraint on your ability to process things as a mere ordinary human. And there, Musk has definitely shown himself not to be the ordinary human, right? He is a risk taker. He's iconoclastic, and he's basically put himself in this position, and it would be a difficult one for other people to emulate. So that's kind of a point that he's got going in favor. The problem is that when you're in that sort of a position where you owe these undivided duties of loyalty to these different companies, that is almost inevitably going to collide with a situation like, oh my gosh, Twitter needs a good data scientist. Let me just pull someone out of Tesla and have them go over there, or have someone from SpaceX go over to Tesla, or have someone from Tesla go over to SpaceX or Neuralink to help them with their things. That then sort of creates a problem about like what belongs to each one of these companies, and that can create issues from a fiduciary perspective. It can also create other issues, like, are these really just all part of the same company? If one of them gets deep into trouble, do its creditors get to claim, hey, look, the boundaries between these companies have been mushed, and therefore you should just allow us to recover from any one of these companies? So that's another reason why lawyers like to try to keep these silos separate. But it's hard to do that with someone who has as many sort of business tentacles as Elon Musk does.
And he seems to be getting more and more tentacles as time goes on. Thanks so much, Eric. That's Professor Eric Talley of Columbia Law School. It's the fourth week of the bribery trial of Senator Bob Menendez, and jurors have had to listen to lengthy testimony about a complex bribery scheme as prosecutors introduced evidence of emails, phone recordings, bank records, gold bars, and hundreds of thousands of dollars in cash. But the testimony picked up yesterday, and jurors were riveted when an undercover FBI agent testified about a video recording she made of the New Jersey Democrat dining and laughing with the wine flowing at an upscale steakhouse in D.C. with his girlfriend and now wife Nadine, his co-defendant Will Hanna, and two Egyptian men. The two FBI surveillance teams were watching someone else and just happened to see Menendez. It's not clear if the Democratic senator was even on the FBI's radar at the time. Joining me is Bloomberg legal reporter David Voreacos, who's covering the trial. So, David, it's kind of remarkable. An FBI surveillance team posing as a couple just happened to be watching someone else at apparently Menendez's favorite restaurant in D.C. and heard an incriminating statement.
In 2019, the FBI surveilled a group of people at Morton's Steakhouse in Washington, and the target of that investigation, we learned in testimony in court this week, was not Bob Menendez, but someone else in the group. And the group included Menendez's then-girlfriend, Nadine Arslanian, who he later married, Menendez, and three other Egyptian men. And there were two surveillance teams at the restaurant, one inside and one outside, it appeared. And they took a number of photographs as well as a video, which jurors saw in federal court in New York this week.
What the FBI agent said she heard is, and the FBI agent testified that she heard Nadine Menendez ask, "What else can the love of my life do for you?" Was that the only bit of conversation that's relevant to the trial?
Yes. The investigative specialist, Terry Williams Thompson, who testified, said that that was what she heard, and they did not record the conversation. When they videotaped this dinner, they were not recording the sound. So that quote certainly suggests that Menendez had agreed to do something for these Egyptian men, and all this was happening at the same time that a co-defendant, Will Hanna, had recently secured an exclusive deal to inspect U.S. meat that was bound for Egypt and was certified as complying with halal standards. And Senator Menendez, we heard in testimony, called the top U.S. Department of Agriculture official who had complained to the Egyptian government that this sudden change in policy on halal meat inspections was hurting U.S. businesses, because there were several other businesses that had previously had this job, and all of a sudden it was down to one business, and that was the one by Will Hanna, and he had no background at all in halal meat inspections. So that USDA official, Ted McKinney, testified last week and this week that he got a call out of the blue from Menendez right around the same time as this dinner, in which Menendez told him to stop interfering with my constituent. And he said that Menendez's tone was curt, and that when McKinney tried to explain what he was doing to Menendez, that the senator interrupted him.
And David, just to be clear, is the bribery charge related to this incident?
There are a couple of charges that it could relate to. One is there's a bribery charge that has to do with Will Hanna seeking Menendez to protect his monopoly. And Menendez is also accused of acting as an unregistered agent of Egypt.
Menendez's defense attorney portrayed this as just an innocent meeting, that the senator goes there all the time. He probably eats at that same restaurant at that same table 250 nights a year. And wow, that's a lot of steak.
The defense said that this was a routine matter for a U.S. senator and that he was acting on behalf of a constituent, that he did not pressure McKinney. He didn't ask him to do anything corrupt.
This was 4 years before the indictment. Does it seem as if the FBI started this investigation then and it continued for 4 years?
Well, we know from prior court filings that the FBI had raided Will Hanna's business in Edgewater, New Jersey, and there was an active investigation of Hanna, and they were looking into whether he was acting as an agent of Egypt. And the FBI employee who testified said that she did not know the subject of the investigation, but it was not Menendez. So that suggests that the FBI was working actively on another angle, and maybe they stumbled on Menendez.
Was the testimony sort of light at certain points? Because I read that the FBI agent was asked whether she ate while she was there, and she said, "I sure did, and it was good too." And then the judge said, "I hope the FBI paid for your meal."
That was definitely a fun moment in the testimony. She was talking about how she, had to dress the part and blend in, and that she was happy to do so at Morton's, which had a great menu.
But I mean, this is the kind of testimony that jurors wake up for after, weeks and weeks of seeing some boring evidence coming in.
She was definitely a captivating witness. And there was a lot about how she plied her craft as a surveillance person. I mean, she apparently goes from job to job to job, blending in, and it was fascinating to hear all this sort of spycraft in action.
The fifth defendant, the defendant who pleaded guilty and will be called in the trial, is his testimony just against Nadine Menendez, or is it also against Bob Menendez?
Jose Uribe is a New Jersey businessman who pleaded guilty and is now cooperating with prosecutors. When he is called to testify, it's expected that he's going to implicate Bob Menendez, Nadine Menendez, and Will Hanna, that they were all engaged in a bribery plot together, and that he can offer an inside account of how this plot, at least as far as he was concerned, advanced. And his role in this case is that a associate of his was under state indictment, and we've reported that Bob Menendez met with the then Attorney General Gurbir Grewal and spoke to him about this case. And there's some dispute about whether he actually asked Grewal to do anything on behalf of Uribe. But the prosecutors say essentially that Uribe bribed Menendez to try to persuade the New Jersey Attorney General to influence the outcome of that indictment. It was an insurance fraud case. And that he also wanted Menendez's help in a second related criminal investigation that did not lead to any charges.
And I ask that question because, as we've discussed, part of Menendez's strategy is to blame his wife. But it seems like in the testimony, he's been implicated as well.
He has been implicated as well, and what his lawyers have been carefully trying to do is parse out the nearly $500,000 in cash and the 13 gold bars that prosecutors say that he received as a result of bribes, and offer innocent explanations for why he received them. And he's also, through cross-examination, tried to show that a series of text messages and emails in which Nadine Menendez, then his girlfriend Nadine Arslanian, arranged a series of meetings with Egyptian officials and Will Hanna that Senator Menendez said were not corrupt and that he had nothing to do in any event with any of the financial problems that his then girlfriend, now wife, was experiencing at the time.
They're going to try to attempt to show that there was no corrupt intent, which is an element of bribery?
That's correct. And that he did not know that his wife was having a lot of financial problems when they got married. It was a second marriage for both of them. And he's also trying to show that his wife was in possession of a number of gold bars that he had nothing to do with, that the gold bars were given to his wife and not to him. And he didn't understand that Nadine's friends were trying to help her out of her financial problems. I mean, that's the defense story.
And we should mention that Nadine Menendez will be tried separately in July. Has there been any indication that he would take the stand?
That's not clear. That's generally a decision that defense lawyers make at the end of a trial after they've assessed how the evidence has come in. I would say that Menendez's political support in New Jersey and in the U.S. Senate has collapsed as a result of this case. Just this week, he filed to run in November for re-election as an independent Democrat because he's lost the support of the party. So I have to assume that any decision on testifying will also involve a political calculation on how the trial is being received publicly. He, of course, wants to be exonerated as a result of this trial and reelected. And there's the challenge he has of answering this very serious indictment and a large amount of evidence against him. He's got to balance that against the story that he tells to the public, which has only heard about the indictment and a lot of the evidence, and it casts him in a very unflattering light.
That is a really good point, because anyone who watches the news saw the photos of his jacket stuffed with cash and the gold bars and the Mercedes. So he has to take a lot into consideration in his decision to testify. This prosecution strikes me as a lot stronger than the last time Menendez was prosecuted.
Senator Menendez's first trial in 2017 was in Newark, New Jersey, in federal court, and he was accused of taking trips and other favors in exchange for helping a Florida eye doctor who wanted his help. And there were some similarities in that Menendez was contacting government officials on Melgen's behalf, but the scale of the gifts in this case is just much larger. The gold bars and the cash are just much more tangible bribes, as alleged by the prosecutors, than they were in the first case, in which the jury deadlocked and the judge ultimately declared a mistrial. In this case, for instance, prosecutors passed around the gold bars so that jurors could actually hold them, and they've seen photographs of the cash that was seized by FBI agents when they raided the house that Bob and Nadine Menendez share in suburban New Jersey.
That is certainly tangible evidence for the jury. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. In other legal news today, an appeals court has halted the Georgia election interference case against former President Donald Trump and others while it reviews a lower court judge's ruling allowing Fulton County District Attorney Fani Willis to remain on the case. While it was already unlikely that the case would go to trial before the November general election, this makes that even more certain. The appeals court said that if oral argument is requested and granted, it's tentatively scheduled for October 4th. The court will then have until mid-March to rule, and the losing side will be able to appeal to the Georgia Supreme Court. If you recall, a Fulton County grand jury in August indicted Trump and 18 others, accusing them of participating in a sprawling scheme to illegally try to overturn the 2020 presidential election in Georgia. They've tried to get Willis and her office removed from the case, arguing that a romantic relationship she had with Special Prosecutor Nathan Wade created a conflict of interest.
On this vote, the yeas are 51, the nays are 39. 3/5 of the senators duly chosen and sworn not having voted in the affirmative. The motion is not agreed to.
A Democratic-led effort to advance a bill aimed at codifying the right to access birth control failed today by a vote of 51 to 39 in the Senate. The bill would have needed 60 votes to advance, and only 2 Republicans, Senator Susan Collins of Maine and Senator Lisa Murkowski of Alaska, crossed party lines to vote with Democrats. Here's Democratic Senator Shaheen of New Hampshire.
This country is failing women in New Hampshire and across the country when it comes to protecting our fundamental freedoms. Fundamental freedoms like the right to contraception, which we thought was safe just a few short years ago.
Republicans had called the vote a stunt and claimed there's no active effort to strip away contraception access in the U.S. But Democrats pointed to a series of public comments as well as state and local legislative proposals that would do just that. In addition, former President Trump recently said he would look at restricting access to contraception if president, but later walked back that comment. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.